Start. In the present case, a feeble argument was advanced that in Master Plan 2021, which was approved in 2006, disputed land has been shown as commercial and therefore at this stage it cannot be said that there is a violation of approved master plan. The submission ignores the fact that the space shown as Ayurvedic garden was for the benefit of citizens of Kanpur city who have a problem of huge air pollution due to large number of industries. They were given an opportunity of getting clean air by developing huge area of disputed land as Ayurvedic garden. This purpose was defeated for the benefit of commercial gain of a corporate individual like the respondent for construction of multiplex recreation center in disputed land was completed in 2002 and was made operational. In master plan of 2021, what development authority has done is that disputed land has been shown in the manner as it was in 2006 without there being any change in earlier plan at any point of time. This is also nothing but an attempt to confer subsequent validity to the blatant illegal act done on the part of respondents by allowing disputed land to be used for commercial purposes without change of use of land in accordance with procedure prescribed in statute and in utter violation of master plan approved and operating in 1999. Therefore, master plan of 2021 in our view will not confer a validity on blatant illegal act of respondent 4 in respect of disputed land which has been converted wholly illegally in a multiplex commercial complex. We also reiterate that huge construction of commercial complex on disputed land made by respondent 4 may have resulted in investment of huge funds and any order of demolition would result in wastage of such investment, but we can neither ignore nor forget that this court is bound by its oath of upholding rule of law. Any direction which may allow continuance of benefit of an illegal act will be nothing but a travesty of justice. We shall be failing in our constitutional duty of upholding majesty of law. Any such attempt would encourage people like respondent 4 to somehow or the other get successful in getting a big construction complete, make it operational even if statutory mandatory provisions are violated to any extent and thereafter go to purchase legality or validity by spending a few bucks. We have deliberately used the words few bucks inasmuch as quantity of the amount cannot mitigate the effect of illegality committed in proceeding against law. Whether one is required to pay a few thousand rupees or few crores or hundred of crores of rupees, but inference would be same that depending on degree a rich and resourceful person can violate law with impunity and purchase validity after paying money, but a poor person lacking funds has no option but to observe law or face punitive consequences. Such an approach would be discriminatory, has to be avoided and discarded without any agitation. Moreover, a message must go to the society that persons who indulge in illegal activities of building constructions for their personal monetary gain and succeed in achieving their evil design with the aid of corrupt means and practices, even going to the extent of purchasing legality for covering their wholly illegal act, as in the present case, shall not be spared and would be dealt with severely. Their illegal structure may be demolished at any stage whenever it comes to the notice of court, or for that matter any other competent authority take cognizance of such violation. As observed above, the facts of the present case amply justify a high-level inquiry into the entire unfortunate episode by an independent agency. However, we leave it open to the system of state government to proceed in this regard in accordance with law and take appropriate action against persons found guilty. Thus, our unhesitant decision is that allotment of land in dispute to respondent 4 for development of a commercial complex, that is multiplex recreation center, in violation of the then existing master plan of 1970 and 1999, wherein disputed land was shown as Ayurvedic garden, was patently illegal. For reasons as discussed above, we also hold that entire constructions raised thereon and functioning of multiplex complex on disputed land by respondent 4 is wholly illegal and amounts to flagrant violation of law. In the result, geodated 18/11/1999, to the extent it directs KDA, in short Kanpur Development Authority, to allow transfer of land to private entrepreneurs for use of commercial land is illegal, and to that extent geodated 18/11/1999 is hereby quashed. Consequently, transfer of land by KDA to respondent 4 is also illegal. We therefore direct that construction raised on disputed land by respondent 4 shall be demolished forthwith without any further delay and thereafter KDA shall restore disputed land as it was at the time of its transfer. Expenses incurred in demolition and restoration of status of land as it was at the time of transfer shall be realized as penal compensation oblique damages from respondent 4. Stop.
Subscribe to our YouTube channel Shorthand Dictation Legal Matters, but never forget to hit on like icon and share with your friends.